Madam Speaker. So, last Friday, late in the evening, we received the order paper for today's meeting. 3 days, therefore, before today's meeting. And it's only, therefore, on Friday, late in the evening, that we learned that the amendment to the main act, the main Declaration of Assets Act, was being withdrawn, a motion from the Prime Minister to withdraw the amendment that we had been considering for quite a while, but also that today we will pass, we are asked to pass a new amendment, first, second, and third reading. Madam Speaker, I'm tempted to say, what a mess. What a mess. So much time wasted. What a mess, so much time wasted. And now we are going to have to wait anew. We know how long we waited for the amendment, the previous amendment that has been withdrawn. How long it took for that amendment to be proclaimed. Months. And then we had to wait for regulations to be made, and now it's going to happen all over again. We're back to square one. What a mess. We're going now to have to wait for the proclamation of the new amendment that is before us. Then we're going to have to wait for ICAC to come forward with new regulations, with a new form. And I agree fully that the form that ICAC prepared was sometimes ridiculous, asking us for the date de naissance of our grandchildren. Stupid, there are some parts of and that shows what ICAC is. So now it's the same ICAC that is going to work on new regulations, on new forms to be filled by all of us. What a mess. And with new delays. We know how long it took for the previous amendment to be proclaimed, how long it took for ICAC to work out forms and regulations. Long delays, and now back to square one all over again. That is why I say, what a mess. So much time wasted. Never mind, one is tempted to ask whether all these procedures that are going to start all anew, whether all this will be done before the general elections. By the tone of the Prime Minister's speech, it's yes. But I stand to be convinced. I stand to be convinced because we've wasted so much time with the previous amendment, and now we're back to square one and we're going to do all this all over again. Having said that, and having expressed the wish to hear the Prime Minister confirm that this new amendment will come into operation, proclamation will be made, new forms, new regulations, as short delays as possible, new delays. Therefore, I hope that the Prime Minister will confirm that all this will be done. I have doubts, but that all this will be done before the next general elections. Having said that, I'll offer a few comments on three aspects of the bill. And one is the judiciary. I was going to ask, but the Prime Minister, Honourable Prime Minister, has already said that it's only recently that he received representations from the judiciary for them to be excluded from the control of ICAC. It's good that the new Chief Justice has made it clear that he agrees, that the judiciary agrees fully that they have to report to some institution, but not ICAC. I agree fully with that. Séparation de pouvoir oblige, but also the credibilité nulle de l'ICAC. We have to report to l'ICAC. We have no choice. But probably they make again a mess of things when I'm speaking. The idea is that we will either designate or set up an appropriate institution to act as depository of the declarations by the judicial officers. Easier said than done. It's not going to be easy, and I hope that the judiciary, the executive having agreed to withdraw the judicial officers from the ambit of this amendment, of the Declaration of Assets Act, I hope that the judiciary itself will come forward with suggestions. And it will not be easy. I heard Honorable Gayan talk about India. Complete difference. In India, it's voluntary. In India, the judges came forward a number of years back, but it's voluntary. There is no law making it a duty for judges to declare their assets. Therefore, the question of which institution receives such declarations doesn't arise. I also heard, I think it's the leader of the opposition, say that the DPP also should be included. No, I believe we have to stop somewhere. And en passant, this morning again I was checking the Constitution. There's something that we should think about, and which has been prevailing since independence. In our Constitution, Chapter 5 is Parliament. Part 1, the National Assembly. Part 2, legislation and proceedings in National Assembly. Therefore, Part 1, Chapter 5, Part 1, Parliament. Chapter 6, the Executive. Chapter 7, the Judiciary. And since independence, both the leader, both the DPP and the leader of the opposition are stuck in Chapter 6, the Executive. I don't know how this arose, but we should do some thinking about it at the time when we are discussing what we are discussing. It's not proper that the DPP, like the Commissioner of Police, or like the civil servants, fall under Chapter 6, the Executive. I think we should remedy that on the first occasion. This is en passant. Therefore, it's easier said than done to appoint or create a new body to receive and control. Noble Gayan is right on that. We can say the Judicial and Legal Service Commission. It's not their job. They are not equipped to inquire, even if required. Therefore, I hope that the judiciary will help us without undue delay, but I say that with due respect, of course, to the judiciary. It is a difficult issue, but it's a very good thing that the new Chief Justice and the judiciary has agreed straight away that judiciary officers, judges, magistrates, judiciary officers will have to declare their assets somewhere, although it's a very difficult situation. I hope, therefore, that the judiciary will help us, will make suggestions, there will be discussions through the appropriate authorities, and that without undue delay, we will find a solution to that difficult one. I understand the reaction concerning ICAC. There is a fundamental issue of separation des pouvoirs, but ICAC, credibilité nulle. Therefore, one can understand the reaction of the judiciary only too well. My second point is the trust. It is our suggestion, it's the MMM suggestion that we include trust. But like somebody has said, it's good that there is this reference to trust property, good. But it's not enough. We must make doubly sure, and the point has been raised by a speaker just before me. That is why I think we should amend the definition, section 2 of the main act. We should amend the definition of assets. Act interpretation, clause 2 of the main act, asset means A, B, C, D. And under D, at present, it reads shares or any interest in a company, society, or partnership. We propose, we think, to be doubly sure, we should amend that so that D reads shares or any interest in a company, society, partnership, or trust. Then we will make doubly sure that this issue of trust is properly dealt with. Finally, there is a question of making the declaration of assets public. The law is clear. ICAC has to make the declarations public. At section 7 of the main act, disclosure of declarations, it says ICAC shall disclose to the public the declarations made by members of the assembly and so on. It has a duty to declare to the public our content of our declaration of assets. But the main act doesn't say how this will be done. And I'm sure we have all been worried recently by les tergiversations de l'ICAC, finding all sorts of formulas. So I doubt whether we can leave that to l'ICAC. That is why the now Prime Minister, on the 12th of December 2018, when he summed up the debate on the Declaration of Assets Act, he said the following, and I quote, let me say that the declared information will be posted on the website of ICAC, and that the public will therefore be able to have access to the information through the internet. And he quoted other countries where this is already done. I think we should have put that in the law, considering what l'ICAC is, and considering the way they are trying to tergiverser, as we say in French. I think we should put that in the law, that l'ICAC will not only have, as I quoted earlier, to make to the public available our Declaration of Assets Act, but how, that it should be spelled out, that it must, on its website, make all the information available to the public. Thank you, Madam Speaker.